Good morning. My name's Terry Hatton, and on behalf of the FFA, I'd like to welcome you to this morning's presentation, LIBOR at the Endgame. A lot can be read into that title, and while we all know the origins of why LIBOR is changing, the hows and when, what happened here in the past and how it continues to evolve, while there's still some questions to be answered, it's clear we're on the road to substantial change, and unless we initiate the change immediately, we're going to fall behind and find ourselves in a very difficult situation. This morning's speaker is Paul Roeder of Moses and Singer. Both Paul and Moses Singer have been strong supporters of the FFA through the years. Paul is co-chair of the Banking and Finance Group at Moses and Singer. Paul regularly counsels his clients on all aspects of LIBOR transition, including the effect on legacy transactions and the use of appropriate documentary provisions. He was an early proponent of LIBOR transition awareness. In fact, in 2018, he organized and moderated one of the first comprehensive panel discussions on LIBOR replacement, bringing together key industry participants, including members of the ARRC and leading trade groups, to advise various LIBOR constituencies on the challenges ahead. Most recently, Paul served as co-chair of the New York City Bar Association's LIBOR Replacement Legislation Working Group. The working group was formed in 2019, consisted of representatives from 9 city bar committees. Over the course of 15 months, Paul and the working group reviewed and analyzed proposed New York State LIBOR Discontinuance legislation. Earlier this year, they concluded that the city bar should support the legislation, and they wrote a detailed paper which is available to you after this call. Paul's here this morning to provide some background on what went wrong and an update on the current state of affairs and answer any questions you may have on LIBOR replacement, SOFR, and the fallback language. I'd encourage you this morning to use the Q&A function to put forward any questions that you may have at any time, and we'll ensure that there's sufficient time to answer them all during the allotted time period. This session is being recorded and will be available on the FFA website for future reference and for those in the different time zones that are unable to attend this morning. With that, I'm going to hand it over to Paul.
Thank you very much, Terry, and good morning, everyone. A special thank you to Terry Hatton and the rest of the FFA board for inviting me to speak here today. And also a special thank you to Cynthia Weibel from Sequence and Michelle Bolingbrook from the FFA. They were instrumental in organizing this presentation and helping me out with the technical aspects. So any technical mistakes you see are mine alone and not theirs. We're gonna start this morning. Let me share my screen. And so our talk this morning, we have a lot to cover. Some of these topics you may be familiar with, others you may not be, and of course there's a lot of news. To briefly outline what we're going to discuss today, I'm going to give you a little bit of background on LIBOR. We all should know what LIBOR is, but it'll be helpful to lay a little bit of the groundwork. From there, we'll talk about what went wrong and the regulatory response to those problems. We'll follow on with LIBOR replacement, SOFR, fallback language, spread adjustments, things of that nature. And then we're going to get to the real heart of the presentation, which were the March 5th announcements from the IBA and the FCA. How those announcements affect our documentation, particularly the ARRC fallback language. We'll then talk about the latest language that came out of ARRC. We'll do a little bit of term SOFR, which I know is a very hot topic for those lenders out there that are looking to find a LIBOR alternative that has term features. And we'll wrap up with a legislative update. After the presentation is done, there'll be a Q&A section. You'll see a Q&A button at the bottom of your screen. Feel free to submit questions. I'm happy to answer them. And without further ado, let us begin. So the background on LIBOR. All right, we all know it's the big behemoth benchmark interest rate. It's published by the ICE Benchmark Administration and regulated by the Financial Conduct Authority in the UK. It covers 5 currencies. There are 7 tenors to each currency, overnight, 1 week, 1 month, 2, 3, 6, and 12 months. Now, the interesting thing about LIBOR is that it was supposed to reflect the average rate at which the large banks can borrow from one another. It's calculated by looking at polling banks, by looking at the rates that banks believe that they could get funding for the various tenors. The most interesting aspect of it, though, it's not based on actual transactions. And that has been proven to be problematic, especially given the size of the market. As you all may know, US dollar LIBOR alone is referenced in an estimated $200 trillion in notional amount of contracts. Now, that $200 trillion number is a bit misleading. There are about 95% of that number relates to derivatives, but still you have 5% of that number is still several trillion dollars, and the loan market constitutes a substantial portion of that. So in any event, we're talking very big numbers. So what went wrong? Well, really 2 things. One was the size of the market. After the financial crisis, there was concern among banks as to their creditworthiness. And rather than lending in an unsecured on an unsecured basis in the LIBOR market, lenders looked to funding sources elsewhere. And this pullback from the market led to a drop in volume. And currently, the LIBOR market is around $500 million in daily transactions. It may sound like a lot, but again, you're comparing it to a $200 trillion number. So this market seems shallow. And regulators took notice of this. After the financial crisis, a number of regulators put a spotlight on LIBOR. And unfortunately, participants in the market didn't help themselves. In 2012, the LIBOR scandal broke. For those of you that remember, there were allegations of fairly widespread fraud and rate manipulation. Essentially, what was happening was, derivatives traders at banks were influencing the submission that these banks were making on the LIBOR panel. That would influence their trades and their deals, and usually it was done to their benefit. This rate manipulation really tarnished LIBOR. The other aspect of the LIBOR scandal was a concern that banks may not have been 100% truthful in what they thought their funding could be in the market when they're making their submissions. And from the bank's perspective, the concern was that if they put a rate that was too high, others in the market might think they were less creditworthy than they are. So there was a concern there as well. And this confluence of issues with LIBOR brought the regulatory response, and the regulators really came in full force. So I set forth on this slide kind of a brief timeline of some of the key actions. Right at the height of the LIBOR scandal in 2012, the BBA, which was the prior administrator of LIBOR, said it was going to transfer oversight to UK regulators. The politicians in the UK then came up with the Financial Services Act. They created a regulatory scheme. They created criminal offenses for fraud, and they also established the FCA, which became the primary regulator of LIBOR. In addition, there was something called the Wheatley Review, and the Wheatley Review was a review by a panel that suggested a number of reforms to make LIBOR less prone to manipulation, more resilient, et cetera. And a number of these reforms were taken into account and came into effect in the 2013 to 2014 period. In 2014, we got a new administrator. So Intercontinental Exchange, through an entity called ICE Benchmark Administration, took over as the new LIBOR administrator from the BBA. Stateside, here in the US, the Fed and the New York Fed convened the Alternative Reference Rates Committee, which we all know as ARRC, or the ARRC, as they like to say. ARRC was tasked with kind of a threefold mission. First, they had to find an alternative benchmark rate. They were looking for, a robust and resilient rate, a rate that couldn't be subject or would be less likely to be subject to manipulation. ARRC also had to prepare a transition plan. We're talking trillions of dollars of financial instruments here, many different types of market participants. Those of us in the loan market tend to think of our market as the end all and be all, but there are, the derivatives market, there's consumer loans, there are floating rate notes, securitizations. I mean, this is a very big task. And ARRC had to put together a plan to get us from LIBOR to SOFR, not an enviable task. The final leg of their mandate, of ARRC's mandate, was to develop best practices. And we see this in the various contract provisions that ARRC has put out over the past several years, all of the fallback language that you see being announced. So from 2014 to 2017, ARRC is working, the UK regulators are working, and then sort of a bombshell is dropped in the summer of 2017. The FCA announces that the panel banks are going to support LIBOR, but only through 2021. From a panel bank's perspective, the risks were getting quite significant. None of these banks wanted the liability associated with submitting these rates. A lot of people weren't using this market anymore for their funding source, and they, essentially a lot of them wanted out. The FCA got them to agree to keep LIBOR going through 2021 and made this announcement. This announcement caused a great deal of concern for lenders and borrowers. The market participants were not sure what to make of this. It really brought this to the fore and made everyone kind of say, what do we do? This is really happening. And that's how we get started with the LIBOR replacement. And it was interesting from the date of the announcement in 2017 until about 2019, we saw a number of banks put out their fallback language, and it varied and was all over the map. And we're going to discuss the fallback language in a little bit of detail in the upcoming slides. But first, I want to talk about SOFR and what it is. We should all have a sense of what it is. I laid forth a couple of bullets here just to give you the overview. SOFR is the secured overnight financing rate. It's intended to be a broad measure of the borrowing costs. And the interesting thing, it's secured by treasuries, and it's based on transactions in the repo markets. The real upside and why ARRC recommended SOFR is threefold. Robust, it's a robust rate, it's not at risk of secession, and it meets international standards. So let's just take these one at a time. It's a robust rate. Why? Well, it's derived from a very deep market. We're talking almost $1 trillion a day in daily volumes related to SOFR. It's regularly 900 billion plus. So you have a very strong, resilient market here. Risk of secession, it's not going anywhere. This is the market that trades in U.S. Treasuries. And there isn't any conceivable way that this market will end anytime soon, absent the end of the world. So, and thirdly, the international standards. So there is a group called IOSCO. It's the International Organization of Securities Commissioners. And IOSCO basically consists of all the securities market financial regulators throughout the world. It includes the CTFC, the SEC here in the US, among many other major regulators. And what IOSCO did is they set forth a detailed set of principles. They covered off on governance, integrity, methodology, and accountability for how you transfer from benchmark rates. And it's kind of viewed as a I don't want to say gold standard, but a very well-respected standard. And any replacement rate wants to be IOSCO compliant. So, that's really where we are with SOFR. The Fed, the New York Fed began publishing SOFR in 2018. It is published every business day around 8 a.m. It's available on the New York Fed's website. So let's highlight really the two key differences here between SOFR and LIBOR and what it means for purposes of LIBOR replacement. So again, SOFR is overnight and essentially risk-free rate. I say essentially because there's always a risk somewhere, but it is viewed and characterized as a risk-free rate. LIBOR, on the other hand, is unsecured. And this unsecured rate does take account bank credit risk, one bank lending to another, and the risk that the institution that is the borrower will not repay is baked into LIBOR. LIBOR is also published for multiple maturities. They're varying tenors, as we said, from overnight up to a year. SOFR does not yet have that characteristic. And that's been a key concern. And we're going to talk about the term SOFR later in this presentation. So because of these key differences, we need a spread adjustment. And this is a very important concept in LIBOR replacement. We cannot just swap in SOFR for LIBOR. There are different types of rates and there's different pricing. The idea with the spread adjustment is that after the transition occurs, we want the parties to the transaction, borrowers and lenders, to be at the same place they were the day before. So we're essentially trying to adjust the spread to make up for the inherent differences in the rates. And this spread adjustment, and we're going to talk about the spread adjustment in details a little later on. The spread adjustment is meant to be an equalizer. It's not going to be perfect, but it is meant to bridge this gap. We really want to try to avoid value transfer or minimize it as much as you can. So the fallback language. Now, the LIBOR fallback language can be quite interesting. It can be cumbersome. For first-time readers, it can be very difficult to understand. So I'm going to first start with a little history. Most loan agreements going back decades had some kind of fallback provision. All right. LIBOR itself has been in the market for 35 years, and syndicated loans starting in the 80s through the 90s, they all started developing their own version of what happens if LIBOR were not available. Typically in the syndicated loan context, and just for notes here, in this presentation, I'm talking mostly about syndicated loans. Obviously, there's bilateral loan fallback language. And I also will tend to focus on US dollar LIBOR rather than the other IBORs for yen and Swiss francs, sterling, et cetera. So what we saw historically was a waterfall. If LIBOR were unavailable, you'd go to reference banks in the London market. You'd poll those banks and take an average of their quotes. If you couldn't get those reference banks to supply quotes, then the agent, if it's a syndicated deal, or the lender, if it's a bilateral deal, would look to the rate it could secure in the London interbank market. And from there, if all else fails, you go to ABR, the alternate base rate. And alternate base rate is essentially the highest of prime, Fed funds plus 50, or 1 month LIBOR plus a spread. So from that history, then ARRC stepped in and promulgated its first set of recommendations on the fallback language. And this came up in 2019. Now, we know there was the amendment approach and the hardwired approach. And we're going to talk a little bit about each of these and then get into further updates. Initially, most participants in the market went with the amendment approach. The amendment approach had the virtue of essentially kicking the can down the road. It was a punt. It was a punt, and it made sense at the time. Participants in the market, lenders were asking borrowers to agree. Lenders who were asking borrowers to agree to a hardwire approach were essentially asking them to agree to rates that didn't exist. And that was really problematic. It was difficult for borrowers to swallow that. So the amendment approach was a good solution at the time. It allowed the parties to just say, when these triggering events, when these transition events occur, the borrower and the agent will agree, and you'll give the lenders or the majority lenders, the required lenders, a veto right over that agreement. And that seemed to work well during this interim period from 2019 through 2020. But clearly, those in the market, they wanted to better understand the replacement rate and how the spread was going to work, what the mechanics would look like. They wanted to see how their systems would work. And then, of course, there was hedging. As many of you know, particularly the large banks in the market hedge most of their portfolios. And if they couldn't match hedging to the new replacement rate, that's a very big problem and risk for those banks. Now, it may not be as much of a risk for the regional and smaller banks, but clearly among the larger banks, hedging is essential. And the lack of insight there was causing some concern. So this led ARRC in 2020 to update the hardwired approach and really push for hardwired approach going forward. The hardwired approach from 2020 on, it clearly had triggers. It referenced a successor rate. It had a spread adjustment mechanism, and it allowed for conforming changes. Briefly, as we know now, if you get, if a trigger event happens, including an early opt-in, your loan will switch over to the benchmark replacement. The benchmark replacement rate. One important point on the benchmark replacement rate is that it includes the spread adjustment, and people often forget this. So when we talk about the replacement rate, we're not talking about just a version of SOFR, be it term SOFR, daily simple SOFR, SOFR compounded in arrears, et cetera. No, what we're talking about is SOFR plus the spread adjustment. That is your replacement rate. And the other point is conforming changes. Admin agents, in particular in the syndicated deals, will likely need a little flexibility to get the provisions in place to work out the wrinkles essentially. And the conforming changes provisions in the 2020 recommendation from ARRC help establish that. And then finally, there's the notices, decisions, and determinations. We're going to talk a little later about LIBOR secession notices, which are part of the hardwired approach. And there's also provisions in the language that deal with who's making decisions and the standards for those decisions. Are they making it in their sole discretion or their reasonable discretion? Now we get to the meat of it. So why was March 5th so important? Well, for two reasons. First, it was National Cheese Doodle Day. Believe it or not, all those Cheetos fans got a national holiday. Secondly, we had two big announcements in the LIBOR world, and we're going to focus on this second point. The IBA announcement comes first. So what did the IBA say? Remember, IBA is the administrator of LIBOR. Well, IBA said that will not have the necessary data to calculate LIBOR settings on a representative basis, and it was ceasing publication of all 35 settings, and it gave the end dates. So on this slide, you see the end game. So sterling, euro, Swiss francs, Japanese yen are all done at the end of 2021. For US dollar LIBOR, 1 week and 2 month are done at the end of 2021. They will cease being published. Then the remaining US dollar LIBOR settings, overnight, 1, 3, 6, and 12 months, will end on June 30th of 2023. And thereafter, LIBOR is essentially gone, subject to the possibility that there may be synthetic rates floating around for a period of time. Now, in the announcement, IBA didn't mention a successor administrator, which is important because when you look at the fallback language, the appointment of a successor administrator would prevent a transition event from occurring. And the IBA also noted that the FCA, the Financial Conduct Authority, could come back and force the IBA to publish LIBOR on a synthetic basis. And the other big announcement was from the FCA, and the FCA basically confirmed what the IBA has said. And it noted that it was going to consult on this issue of synthetic LIBOR. And essentially, synthetic LIBOR is a concept that was developed to provide a little more stability, a little more leeway. And the idea, which it hasn't been announced, it's not clear it's going to go forward, is that the FCA would compel the IBA to produce a synthetic version of LIBOR for a certain period of time for certain currencies. And there's been talk about a synthetic one for USD, for sterling, and for yen. And the idea is there may be some legacy contracts that will not be done by the end dates. And a synthetic LIBOR would help ease that transition for those real tough legacy contracts. Just also a note in the slides, which will be available on the FFA website, I've included the links to various announcements and documents for your reference. If you want to see the primary sources on any of these materials. So now we get into the real key questions on what these two big announcements mean for purposes of our documentation. Again, to be clear, we're assuming that most market participants have adopted or are adopting ARRC's hardwired approach language, or at least have the amendment approach language in their existing documentation. And we're focused here more on US dollar LIBOR, but it does apply to the other LIBOR currencies as well. So the big question, has a benchmark transition event occurred? Yes, it has. The announcements from the IBA and the FCA constitute benchmark transition events under the ARRC language. That has been confirmed. ARRC actually put out a statement to that effect. And we have gone through the first hurdle in this transition process, at least from a documentation front. Now that leads to the second question, which is, do I have to transition to the benchmark replacement now? Well, the answer is no. You don't have to do it immediately. And this is important for a lot of people to understand. When you look at the fallback language, there are essentially two triggering events that have to happen. One is the transition event, which is essentially the announcements that happened on March 5th. But the second leg of it is the replacement date has to occur. The benchmark replacement date has to occur. And that has not happened yet. We know that for a number of the currencies, it'll be at the end, a number of the tenors and currencies, it'll be at the end of this year. And for the remaining US dollar tenors, it'll be in June of 2023. So you do not have to switch right now. But if you have the early opt-in election, which is embedded in the ARRC recommended language, you can seek to switch over based on whatever conditions are set forth in your contract. Whether there has to be a certain number of deals in the market that are using a SOFR linked rate or not. But that's where we stand with respect to which rate we're using today. Now, what about the FCA and the idea of a synthetic benchmark? So if the FCA came out and announced that it would require IBA to produce a synthetic LIBOR, the FCA has made clear that that rate would no longer be representative. And that's quite important because representativeness is one of the key tests under the fallback language. So it would not be representative, and that announcement of it not being representative would also constitute a benchmark transition event. So we move to spread adjustments. Now, so as we discussed earlier, the spread adjustment is intended, it's the mechanism that is used to minimize value transfer when you're moving from LIBOR to SOFR. And a few points on the spread adjustments. So ISDA released a statement that the release of the March 5th announcements constituted the index secession event under its documentation. And as a result of that, Bloomberg, which was publishing the spread adjustments for the various currencies, was required to fix the spread adjustments on March 5th. You'll see here in the second bullet that there is a link to these spread adjustments. So these spread adjustments are now fixed. We know what they're going to be for the various currencies and the various tenors. What I found interesting about the spread adjustments was how small they were. Frankly, I thought they were going to be a little more significant than they turned out to be. And I'll give you just a couple examples. 1 month LIBOR, the spread adjustment is roughly 11.5 basis points. Okay. 3 month LIBOR, it was around 26 basis points. And that's for US dollar. What was also interesting is that for Swiss francs and Japanese yen, the spread adjustment was actually negative, which I guess is par for course, but yeah, interesting nonetheless. Now, what do we do going forward? This is a very key point. So, I have heard some lenders in the space say, well, listen, most of the US dollar LIBOR tenors will be available until June of 2023. That's quite some time away. We're talking almost 2 years or so from now. So should they continue to use these tenors in their loans going forward? No, you should not. After December 31st, 2021, you should not. Back in December, the FDIC, the OCC, and the Fed put out a joint statement. And that statement said that lenders subject to their regulation should not use these LIBOR values after December 31st, 2021, and they should make all efforts to end earlier if possible. What the regulator cited was safety and soundness, and that's a phrase that will strike terror in the hearts of banks. From the regulator's perspective, they may not view it as safe and sound banking practice to continue with LIBOR after the end of this year. And that should be a clear sign to everyone in the market that LIBOR is going away and you have to stop writing LIBOR contracts. The final point here deals with the secession notices. So the fallback language in both the syndicated and the bilateral context have a requirement that the agent, if it's syndicated, or the lender, if it's a bilateral deal, provide notice. So in the syndicated context, agents should be providing LIBOR secession notices to their borrowers and to their lending groups. If your institution has not done so, you ought to look into that. If you're using the ARRC fallback language, the LIBOR secession notices are required. They should be given. They help protect all of the parties and put everyone on notice as to what's going on. And from a practical perspective, it's particularly important, I think, for borrowers. Lenders are steeped in this. They have regular updates. Many of them have their finger on the pulse of LIBOR replacement. They're members of ARRC. They know what's going on. But you can't always say that about borrowers, notwithstanding that borrowers are very sophisticated these days, and particularly in the fund finance market, you're dealing with, borrowers that are in and of themselves major financial institutions. Nonetheless, if you haven't given LIBOR secession notices, you should be, if you're using the ARRC recommended language. And on that front, the LSTA, the Loan Syndication and Trading Association, put out a form of LIBOR secession notice that, in my experience, I'm seeing a number of banks use or slightly modify and use. For members of the LSTA, it's available on their website, along with a number of other useful materials related to LIBOR replacement. So, after the announcements, ARRC came out with a further updated version of the hardwired fallback language. And this was released March 25th of this year. It was interesting. The biggest complaint I received from clients was the complexity of the replacement language. Not so much the amendment approach, maybe a little bit, but certainly the hardwired approach, and just the nuance and detail and the number of definitions. It was a slog to get through those provisions the first time. And really, that's not intended as any criticism to ARRC. It's a difficult subject. It's nuanced. As a lawyer, I know that oftentimes you need a lot of words to describe something accurately. You need a lot of defined terms to be very precise. but the language was cumbersome. So what ARRC did in its most recent pronouncement is they took the 2020 language, the 2020 hardwired language, and shortened it. Okay, they didn't really change the concepts. So you essentially have the same theory, the same concept underlying the fallback language. But what they did do was simplify the language. They basically baked in the fact that these statements constituted the benchmark transition event. And they were able to remove a number of definitions, clarify a few other provisions, and essentially shorten and simplify the language. If you're not familiar with it, you should take a look. It's available on ARRC's website. And for new deals going forward or amendments to existing deals, you should consider whether or not this language is a better fit for your institution. And one thing not to worry, if you have the 2020 language, 2020 hardwired language, it still works. You'll get the same result. But if you want to make it a little easier on the eyes, you should consider the 2020 language. So let's talk a little bit about term SOFR, which is a real hot topic and a key source of concern for both lenders and borrowers. As you know, right now, term SOFR doesn't exist. Now, there was a recent announcement last week that I'm going to get to, so maybe it will be in existence, or is in existence, but this was the big concern that market participants had. There wasn't a term SOFR that corresponded with the tenors available for LIBOR, so 1 month, 3 month, 6 month, whatever. And without this forward-looking term rate, market participants are stuck with, daily simple SOFR, SOFR compounded in arrears, compounded SOFR in advance. These calculations can be cumbersome. They don't provide that forward-looking ability. It makes it difficult for the parties to really plan out, financially plan out their short-term borrowings. And unfortunately, last month, ARRC said something that roiled the market a bit, and that was they may not be in a position to recommend a term SOFR rate by the end of this year. And you had a lot of lenders out there scratching their heads saying, we're putting in all of this hardwired language. The assumption is that by the end of the year, or maybe shortly thereafter, we would have some kind of term SOFR rate that we would use. Now you're telling me it may not happen. Well, it appears that ARRC, understood the concern that they raised. So a few weeks later, they put out these key principles, and these key principles are what they will use to evaluate any term SOFR rates that come into the market. Essentially, they are that the term rate has to be similar to SOFR itself. It has to follow ARRC's criteria and methodology for the alternative reference rates. They also want it to be robust, the favorite word of ARRC, robust and sustainable, and based on kind of a deep well of derivative transactions over time. And finally, they want it to have a limited use. They don't want to make this out of proportion to the underlying market from which it's derived, or to detract from the volumes in that underlying market. So they want a stable rate that will last over time. Now, last week, the day after this announcement came out from ARRC, CME, the Chicago Mercantile Exchange, announced its launch of term SOFR. And this term SOFR would have 1, 3, and 6 month tenors. CME reports, and this is still being studied by the major participants, but CME reports that their term SOFR rate is aligned with ARRC. It's IOSCO and BMR compliant. It comes from their deep market. The CME group runs one of the largest derivative markets out there, and they have this deep SOFR futures market. And to address concerns about usage, for now, CME is going to limit it to the cash market, so loans, for example, until the end date of the remaining US dollar LIBOR tenors. and they're going to keep that available make that available at no charge. So as we move on, one, I thank you very much for your time and attention today. And I have just one more point that we want to discuss, which is legislation. And so really interesting things were happening in the legislative front. Last year, about a year and a half ago, actually, ARRC proposed LIBOR discontinuance legislation. And they proposed doing it in New York State. So, all right, first, why New York? Well, New York is the commercial center of the United States and arguably the world. Many, many, many contracts are governed by New York law. The idea was for those tough legacy contracts that either did not have adequate fallback language or couldn't be amended to add adequate fallback language, we wanted, they wanted an ultimate backstop. So over the course of the past year, the ARRC proposed legislation made its way through the New York Senate and Assembly. Thankfully, in my opinion, the governor signed it into law a few weeks ago, and New York now is the first state and only state in the US that has some version of a discontinuance statute relative to LIBOR. So what does this statute do? Well, I'll give you the high points. All right. One, it provides for SOFR as a fallback after LIBOR ceases publication. All right, so it's giving you a fallback rate. Now, interestingly, if you already have a fallback rate, or you have a mechanism to get you to a fallback rate, and that mechanism doesn't reference LIBOR, then you do not have to use SOFR. So if you were going to use a Maribor or some other reference rate, you're free to do so. The parties are free to contract around this statute. The good thing about the statute, though, is it does provide a safe harbor from litigation. One of the really key concerns in the market was that if there weren't some ultimate fallback legislative response, there could be a flood of lawsuits. And not just in, and really this may not affect cash products such as loans. The loan market has been pretty good historically and currently with getting replacement language into their documentation. But if you look at other types of products, in the securitization market, derivative products, there's other products where the parties may not be able to amend it. Think of bonds subject to an indenture. Arguably you need the consent of all of the holders of all of the holders of the notes of the bonds to change the interest rate, and that is never going to happen. So they're kind of stuck. So what this statute would do was it would insert LIBOR, SOFR in place of LIBOR. And this safe harbor is thought as a very important aspect of this. For your benefit, I've included a link to the statute itself. This is the Senate version, which is the version that was passed. And I also include a plug. I also include a plug to the New York City Bar Association report. As Terry mentioned in the intro, I was very happy to co-chair the working group of the City Bar that analyzed this statute and produced a report supporting the statute. For those of you that are interested in the history and the nuances and kind of the market beyond just the loan market and what the statute does and says, please feel free to check out our report. Final point on legislation, and after this we can move on to our Q&A session, is federal legislation. Now, there have been talks for about a year now about federal legislation coming out of Congress. Representative Brad Sherman has been working on legislation. There have been a number of committee meetings discussing it. And it's still quite fluid, it's quite malleable. There is talk that the federal legislation could mirror some of the key points from the New York statute. My understanding is that ARRC hasn't been heavily involved in the federal legislation. There have been other constituencies that have been pushing it. A number of trade groups about a week or two ago released a letter supporting the push for federal legislation. Where this is going to go, it's not clear. From my perspective, I think the really big point that would have to be addressed is the Trust Indenture Act and doing something about the amendment provisions, because I think that's where there could be significant dislocation and really only federal legislation can fix that. That is a federal issue. It's not merely just going to be a state issue. So with that, I want to thank you all for your attention today. I appreciate your time. We're happy to. I'm happy to take questions. Before I do that, though, I need to be a lawyer and show you all the disclaimers. This is not legal advice. It may constitute attorney advertising. And with that, we will go to your questions. Now, remember to please use the Q&A function. And I believe Terry will be joining us now.
Yeah, thanks very much, Paul. Hopefully you can hear me now.
I can hear you.
Great. Paul, just a couple of quick questions before we hit some of the others. The information was very informative, and I kind of had a couple of questions as you went along, and I'm thinking kind of globally. Does the transition from LIBOR to SOFR affect the fund finance space differently than other areas of finance? And are there any unique features of, say, a subscription facility or other fund finance product that kind of deserve special attention in respect of LIBOR replacement?
Yeah, good question. I think the answer is LIBOR replacement doesn't really affect the fund finance market differently than other finance markets. Clearly, when you think of the credit documentation used in a subscription facility or a NAV or hybrid facility, you're essentially, most banks essentially use their form of revolver or their form of term loan, depending on the type of facility it is, and build in subscription facility provisions into that. So what that means is that the underlying mechanics are essentially the same type of mechanics that you get in a standard revolver. So I don't see LIBOR replacement having any different effect. I mean, clearly it will have an effect, as it will to all lenders and borrowers in the market, but I don't see it really as being different. The mechanics should all essentially be the same.
Okay. Is there anywhere, given all these announcements, is there anything that's published sort of best practices in kind of addressing the language overall? Has there anybody, whether it's ARRC or whomever, have they published anything specific other than hardwire all deals?
Yeah. Yes. I mean, ARRC has had some announcements. LSTA has had some announcements. Many law firms that comment on LIBOR replacement have suggestions. A Google search will reveal this. I wouldn't point to any one particular set of best practices as being primary. There are, in my view, really three or four points that I would make. One I made during the presentation is just getting the notices out. LIBOR secession notices should be sent out. If you haven't done it, do it if you're using the ARRC language. The other thing is what ARRC and the regulators are really pounding on right now, which is use the hardwired fallback language. Everyone understands the amendment language is easier. It's the great punt, the great kick the can down the road. But now we see the end of the road. So put the hardwired language in. To the extent you can, and with the new language that ARRC put out, it's much easier, it's shorter, it's simpler to understand, and it's clearer. We know what the spread adjustment's going to be, and you could bake that right into the language like ARRC did. Another suggestion of best practice, and this came up recently on a deal I was working on a few weeks ago. It was actually a subscription facility. For LIBOR tenors, the lender was proposing including 1 week and 2 month LIBOR settings for US dollars. And the announcements had already been made. Everyone knew that these settings are going to disappear at the end of the year. So why would you put that in a 3-year deal? Just to make your own lives easier, I would suggest dispensing with those two tenors now. We know they're going away. They're not very highly used in the market anyway. It's really 1, 3, 6 month that people look to. So if you can take 1 week and 2 month out now, and Finally, is the big point is everyone has to realize that you just shouldn't be writing LIBOR contracts. Your loans shouldn't be referencing LIBOR after the end of this year. It's not good practice. The regulators have said it. The practitioners have said it. We are moving to LIBOR. There's kind of no turning back now. So get on board and move forward would be my best practice suggestion.
Sure. Paul, there's a few questions that came in through the Q&A. Can you address those?
Sure. Let me take a look here at the questions. All right. First question. Do we have an estimate for the percentage of deals that have amendment versus hardwired? No, I do not have a specific percentage. I can talk anecdotally, and I think it really relates to what we saw early in 2019 to the 2020 period. And during that period, everyone was opting for the amendment approach. So that has been more prevalent. However, again, anecdotally, what I'm seeing now is this hard push to the hardwired language. I would say most, and I would probably venture 3/4 of the deals I'm seeing now have the hardwired approach, and not the latest version that came out last month from ARRC, but the variation of that version from last summer is out there. So yeah, I don't have any firm numbers, and I haven't seen any published, but that's kind of where we stand. Let me move to another question. Is there a market consensus on the spread adjustment for daily simple SOFR? So the spread adjustments have been fixed, and those have been published. You'll see in our presentation that when we're moving from LIBOR to SOFR, those spread adjustments are there. I'm not aware of any other spread adjustments. Those really, the Bloomberg ones are the ones we're looking at. So let me move to another question here. Here's an interesting question about the divergence in the U.S. and U.K. markets. So the person who submitted this question asks the following: will there be a fundamental divergence between how interest is calculated in the U.S. versus the U.K. markets, given that UK regulators have said they see limited usage for terms SONIA? And in the UK, the LMA documents are recommending using compounding in arrears for both sterling and US dollars. Yeah, I do. I mean, I do see a divergence there. The market participants, particularly lenders that I speak with, are all proponents of term SOFR. It appears that there's a strong demand from their customers, from their borrowers, to get term SOFR, and clearly, the LIBOR terms have been used for many years, and are really a fundamental aspect of the nature of these short-term borrowings. So I do see it splitting. As for the UK market, I personally don't practice enough in that market to give you a sense of what's going on there. So I don't want to get out in front of my skis, but clearly, if what you're describing is correct, then yeah, I would see a divergence there. Okay, let's see. I think we have one more question. All right. So question here. So talking about replacement SOFR, what are banks gearing up with? Compounded in arrears, in advance. What about daily simple SOFR? Anyone using it yet? Well, thank you for that question. What we're seeing from our perspective, a lot of banks are using, we're seeing a lot of daily simple SOFR, probably because of the ease in the computation, and it's simpler to explain. I have seen compounded in arrears in a few transactions. I have not, and again, this is anecdotal, but I do see a fair amount of deals in the market. I have not seen a lot of compounded in advance. Now, one point on compounded in arrears, which is kind of interesting, is there's been a lot of discussion about a look back. So if you're doing compounded SOFRs in arrears, we have an interest payment date. Say it's a 1 month period, and the borrower has to pay interest at the end of that interest period. The concern with compounded in arrears has been, how do you calculate that amount such that the borrower can pay it at the end of the interest period when you wouldn't know the value that you're using, until essentially the next day, the last day value. And what a lot of lenders have been looking to do is a look back. So say you look back 1 week, there's a 1 week lag. And what that affords you if you're using compounded in arrears is when you're actually getting to your end of your interest period, you know what the set amount is because the value that you're looking at is from a week before. So your borrowers can make those payments at the end of that interest period. So I'm looking here, seeing if there are any other questions. I believe we've gone through.
Hey, Paul, let me ask you one last question to kind of sum up, and I really appreciate your time this morning. Look, how do you think this whole thing is going to play out? Do you think that there's a smooth transition here, or do you think this is just going to be Armageddon at the end of the day?
It's funny. If you had asked me that question about 3 months ago, I would have been much more pessimistic. Kind of the end of 20, beginning of 21, there wasn't a lot of clarity. All we knew was that LIBOR was ending at the end of 2021. And, in my opinion, many people were not prepared. I think everyone had been taking it seriously, particularly from middle of 19 through 2020. But, that urgency and that realization that it was going to end at the end of 2021 gave me a great deal of concern. Now, when they announced now that they're pushing the US dollar LIBOR settings out to 2023, I got a lot more confident that this is going to work and that we're going to have a more smooth transition. Will it be perfect? No, it will not be. But when you look at this, there's now a couple of years left. Many participants are using the fallback language. In New York, at least, we have this fallback statute, kind of a last-ditch effort, a firewall there. So I am reasonably confident that things will go well. And I just encourage everyone to stay on top of this, to follow best practices, and to really embrace this change and run with it, and protect your institutions from these types of risks.
Sure. Well, I know we're inserting it wherever we can, and we're all over this. Paul, thank you very much for getting on this morning. Thank you for all of the information. It's obviously helpful and informative to our audience. Thank you for getting on. Thank you for your support. Just before we go, I wanted to remind you that there is the Next Gen presentation tomorrow morning, sharply entitled "No Crude Jokes, a Private Capital and Advisory View on Oil and Gas." So that promises to be a great presentation. As mentioned, a recording is available, as are the slides from this morning on the FFA website, and our calendar of events for not only the FFA, but Women in Finance, Next Gen, and Diversity in Fund Finance. All those calendar events are available. So again, thank you for your time this morning. Thank you, Paul, and we look forward to seeing you again soon.
Thank you all. Thanks, Terry.